Welcome back to DBS and the DFL studio. Tonight we're talking about wills and understanding what you can and can't will and much more. Our special giveaway tonight, Do Law Factor Live offers 2 of our viewers 50% off the cost of a consultation with any attorney at law once it is a consultation that will help you to produce a will. To do this, all we'd like you to do is tell us why you think you should receive the 50% off. So in other words, tell us why you think you should win this prize. We'll be choosing 2 winners tonight. With me is attorney at law, Ms. Veronica Snack. Veronica, for those who missed the show last week, can you tell us a little bit about your practice, please?
I have been in practice for the last 15 years, approximately. Mixture of private practice and also quite a few years in the government service in the Attorney General's Chambers and Ministry of Legal Affairs. For now, I have my own chambers, and as with most solutions, I do a general practice with some specialization in areas of human rights, property issues, succession issues, etc., and some company law.
Okay, great. And you have a joy or a love talking about the laws of succession.
I actually do love succession. When I did succession as a student at law school, I have to say it was my best course, is across the board. But it is something that, particularly for St. Lucia, it is so, I would say, not complicated, but so involved. That it always raises so many different questions. There's always some situation that arises that we're not exactly sure how the law deals with it, and you're constantly going and reading and finding out. So it's really challenging. It's very interesting.
Good. Well, last week we spoke a lot about, a lot of the stories that we were hearing about people not leaving wills and so on and so forth. And so we thought this week what we'll talk about is when you're thinking about it, actually thinking about the will, what should you be thinking about? Are there do's and don'ts? Are there shortcuts? What are the benefits of making a will right now? And I think a lot of it is facing some fears as well. There's a lot to it. So we thought let's start at the beginning. Let's talk about, we know why you should, but let's now maybe think about, why, what are the things that we have to leave? What can we leave? Some people, they just leave behind land, but they forget that even though the property isn't theirs, maybe the contents in their house is theirs, and they just don't remember those things. So that's what we're going to be talking about, and we're going to be opening the phone lines a little earlier tonight to give you an opportunity if you have any questions to ask. But first of all, Veronica, can I ask you, are there different types of wills? Because we always say, I'm going to make a will, and maybe some people think there's just one will, and that's the way you do it.
No, we in our law we recognize 3 types of wills. One is the notarial will, which is executed before 2 notaries, or 1 notary and 2 witnesses. So you would give 1 notary your instructions, and that person records it, and in the presence of another notary reads it back to you to ensure that these are the instructions that you have given, and both and yourself, that you call the testator, you execute that will. Of course, there's some restrictions. The notaries cannot be related to each other, brother, sister, father, son, nephew, and uncle, etc., so that there's no issue of, if you want to call it, collusion and things like that. And also the notaries cannot accept gifts under the will. We also have another form called an English will, which is a will which can be typed up or handwritten, but it is witnessed by two witnesses, one of whom must be a GP. And that is typical of an English will, so it is referred to as an English will in our law. And the third one, which is extremely simple, and if you don't want to go into a lawyer's office, you can sit and do it yourself. It is called a holograph will. It is really a will in your own handwriting, signed by you. So you can sit and write your will, just inform somebody that you have the will, and ensure it is in your own handwriting. You cannot have somebody write it for you. You should write the will yourself and sign it. And you don't need a witness in that case.
You don't need a witness? You don't need a lawyer?
No, for a holograph will.
You don't need someone to say, you are of sane mind?
You can say that. When you're coming to prove the will, when you're applying for probate, then it becomes an issue. So in the scheme of things, the best form would be the notarial will. The notarial will is generally, it raises less issues of fraud, etc. And so most people opt for the notarial will in St. Lucia, and that is what, as attorneys, we recommend. Not for a fee issue, but it is something that you ensure that you consider all the necessaries. You take into account things that you maybe would not have considered, you know, had you not approached an attorney. So the notarial will is what we generally advise.
Could you give us maybe ballpark figures for fees that are attached to these wills?
Yeah, well, all different attorneys charge different prices, but generally speaking, at least what I recall, a will is not very expensive at all. It's about 600 EC dollars to do a will, which is, in the scheme of things, not that much money. It's pretty much of a standard form. You know, there are certain things that you must consider. You have to consider, first of all, what assets do you have? And as you said, the assets might be what we consider movable or immovable. Very simple. Immovable assets generally deal with property, land. There's a sort of a simple understanding of it, and most of the things are considered to be movable property. So your furniture and things like that can actually physically move, movable property. You have to consider who you're going to leave those things to. But in terms of formalities, you will need to consider who is going to be the executor of your will. And the person who is the executor is going to be the one who is going to have the responsibility of applying for a grant of probate, and they will have the responsibility of passing on the contents or your estate to the heirs as determined by you in your will. Their responsibility is to ensure that your intentions as stated in your will are complied with.
Now, I would say it's a fair thing then, if you are going to name someone as the executor of your will, to at least ask them before, because it's a huge responsibility.
Yes,
and not everyone is cut out to do that or feel comfortable to be, you know, dealing with the law. Would you advise people to at least ask someone first if they're willing to do so?
Absolutely. It is extremely important. It is not only time consuming, but sometimes costly too. Because if the estate is, say for example, a lot of immovable property and there are no liquid assets, there are no funds sitting anywhere, who is paying for the probate of the will, so that, you know, the property can pass or it can be sold, etc.? Somebody has to pay for it. Usually the heirs pay for it. But the executor has a lot of work. The executor is the one to visit an attorney, to apply for the grant of probate, to determine what is the estate of that person. Because the other thing that we don't consider is that at the time that you do a will, you would have included what you believe to be what you are entitled to, what your estate is. After you've passed, you might have become the owner, or you may have been entitled to other things that you did not consider in your will, right? And all that is taken into account, which is another formality in terms of the will, is that there are certain clauses, and one of the clauses is called the residuary clause, which takes into account if any property or any asset, any part of the estate that you may not be aware of at the time of executing the will, then there is a blanket clause that says who that property goes to, right? If you do not have a clause to that effect, then, and you do not mention that property in your will, then that property devolves to your heirs by way of intestate succession. So put it simply, what it means that the will only govern those things that are mentioned in the will, and then the law of the country will govern that property that you did not consider in your will if you do not have the residuary clause.
Wow. Okay. Now, does that become even more complicated if, for example, you died out of the country and you have property in St. Lucia and out of St. Lucia? And as I'm saying this, I just want to tell viewers, last week when we came off air, I actually got home and I got a call from my aunt to say that my uncle in England had passed away, and now it's kind of my duty here because he's in England, although they're in St. Lucia, and I'll say his name in case people don't know, Mr. Joseph Gideon of Bonterre, and my aunt is Stephanie Gideon, of course, formerly Stephanie Delore. My thoughts are with you and the rest of the family. And so it was just ironic that we were talking about it, and I come home and I hear this kind of news. So when we are looking at making wills, it's not just a matter of what we're leaving for people. We have to know what, I wouldn't say what our rights are, what's the word I'm looking for? Not what our rights, but we have to know about, you know, how can we distribute and all those kind of things. It's best to not guess it and to visit an attorney who can advise you correctly. So going back to the initial question, what happens then if, for example, you have property in St. Lucia and abroad? Does it really matter where you passed or where your will was made?
Yes, it does make sense. And I have to say, I'm sorry to hear about your uncle.
Thank you.
It was really, it was just incredible right after the show. Something else. In the will, well, property is, or the management of property is generally concerned, well, controlled by the law of the country where that property is located, especially if it is immovable property. If it is movable property, it's according to our law in St. Lucia, it is based on the domicile. Your domicile is where you live, right? So if you have movable property, then what governs that property is based on the law of the country where you live, where you're habitually resident. In respect of immovable property, the law that governs that property is the law of that country where that property is located. So you have to be careful when you have assets in different countries that your will takes into account those assets. It may be that you might need another instrument in another country to ensure that it's going to be acceptable. I mean, there's a possibility, and it's a little complicated, I have to say, so I don't want to go into too much, of registering, getting probate in one country and then registering it in another country so that it can be done. And some people, it really is a nightmare. It's a long time consuming process, and that's even when where you have a will. So sometimes it is better for you to leave a will that deals with the property in a particular jurisdiction, so that it is done in accordance with, because some jurisdictions may not recognize our form of wills. So if you do not consider that, then it's as if you do not have a will in that other jurisdiction.
Right.
And then your property goes the way of the law of that country, not what you intended at all. So the whole conflict of laws issues. It becomes a little complicated when you have properties in different jurisdictions. It's complicated enough in St. Lucia alone so far.
Much less, yes. And of course we're talking about property, but sometimes it's not about property. You know, it could be about your personal belongings, because not everyone has a property. And you think, well, you know what, I don't have a property, I've got nothing to leave. Well, yes, you do. You know, you have certain heirlooms, you have certain things that people want.
You have to consider your personal things, your clothes, your treasured items. There might be things of sentimental value, and sentimental value things, it hurts somebody that you walk into somebody's house and you see your mother's center table that you grew up with in your house. I mean, these things are important to people, and people underestimate it, and it's unfortunate. But things like that, you have to consider the monies in accounts. What you're going to do? I mean, think practically. You know, how are people going to access the money in the accounts? There are things that you can put in place to do that. You have to consider if you have shares in a company, what's going to happen to those shares in the company. You have to consider if you have minor children, what will happen, who will assume guardianship of your minor children. A lot of people leave that totally, you know, unregulated in that regard. So
there's a lot to think about, and we're going to talk about that a bit more later. But just before we go to the break, a quick reminder of giveaways tonight. To win a brunch for two at the Bay Gardens Beach Resort and Spa on Father's Day, June 17, submit a recipe along with a photo or video of you and your dad in action in the kitchen by Monday, June the 11th. Win Farron's ice cream and lunch for you and your dad with Chef Robbie, courtesy of Farron's Dairy. Create a dessert using your favorite Farron's ice cream flavors, which you'll win as part of your prize. Do this by Monday, June the 11th. What is the name of the lizard that appears in all the Rainforest Hideaway ads? Check Rainforest Hideaway on Facebook for the answer to that. How long has Sisson's Infinity Color Shop been in operation? Answer correctly and you can win a fantastic package that Dad is going to love. You can find the questions on DeLawFactorLive.com and Facebook, DeLaw Factor Live TV show. And of course, DeLaw Factor Live is offering to pay 50%, that's 50% off your costs of your first consultation with any attorney at law. Once you can tell us, you can prove to us that you are going to do a well. You're watching DeLaw Factor Live on DBS. Stay with us.